Hello, and welcome to the review of Procedure MG-O-004.05. Today, we will cover procedures related to obtaining consent for research from a surrogate. Before we begin, it is important to address why this procedure is important to clinical research. The purpose of this procedure is to establish a consistent method for enrolling subjects with diminished capacity or impaired consent capacity in research via consent of a legally authorized representative or surrogate. Please note, if a prospective research subject cannot consent on their behalf, federal regulations permit researchers to obtain consent from a legally authorized representative or surrogate. Informed consent is a key element of research with human subjects, especially in vulnerable populations. As such, it is important to identify those who are responsible for the process's correct implementation. The scope of this procedure applies to all individuals and designated research staff who have the responsibility of obtaining and documenting informed consent from living individuals involved in human subject research. All research activity administered by MedStar Health facilities, all affiliated and satellite locations, MedStar Georgetown University Hospital, and Georgetown University Medical Center, or MedStar Georgetown. Studies where the IRB and sponsor have approved the use of a legally authorized representative or surrogate to consent for the enrollment of the subject in the study.
Throughout this presentation, there are many key terms that will be utilized. Informed consent process and legally authorized representative or surrogate decision maker are two definitions in particular that require some special attention. The informed consent process is discussed in greater detail in Procedure MG-O-004.05, titled Informed Consent Process and Documentation. Legally authorized representative or surrogate decision maker is when an individual, judicial, or other body is authorized under applicable law to consent on behalf of a prospective subject to the subject's participation in the procedure involved in the research. An LAR can be anyone, such as a spouse, child, caregiver, as long as they have legally authorized ability to do so. Additional terms that will not be defined in this training include institutional review board, principal investigator, and research. If you are unfamiliar with any of these terms, please take a moment to pause this video and visit the MedStar Georgetown glossary to obtain the definition of the unfamiliar terms.
Informed consent is a key element of research with human subjects. As such, it is important to identify those who are responsible for the process's correct implementation. The principal investigator and designated research staff are responsible for understanding and following the basic tenets and regulations regarding informed consent as outlined in Procedure MG-O-004.01. If you have not yet viewed this procedure, it is highly encouraged for you to please review informed consent process and documentation before continuing this procedure. The PI and research staff are also responsible for understanding any local laws and regulations regarding obtaining informed consent from a surrogate decision maker when the IRB and sponsor have approved the use of a legally authorized representative or surrogate. In the first part of this procedural review, we have introduced the purpose, scope, and some key information about the procedure. We are now going to transition into discussing informed consent procedures as it relates to obtaining consent from a surrogate. Before beginning the consent process with the legally authorized representative or surrogate, some collaboration with the IRB is necessary. One of the most important requirements is receiving approval to obtain consent. IRB and sponsors' approval must be obtained before using a legally authorized representative or surrogate for consent. Refer to the IRB of record for policies on when surrogate consent is permitted, as it may be limited in certain types of research. When requesting approval to use a legally authorized representative or surrogate for consent from the IRB, the protocol and consent plan must include specific plans for assessment of decision-making capacity of the subject. Included within the submission to the IRB, there is an expectation of certain safeguards put into place to protect the rights, welfare, and safety of subjects with diminished or impaired capacity to consent. Some of these safeguards include risk-benefit ratio, adequacy of assessment plan, monitoring of subjects' capacity, and appropriate use of LAR or surrogate. The subject's ability to consent is a major factor in the utilization of a legally authorized representative or surrogate. The PI must consider the level of subject impairment. These categories include partial impairment, impairment that may fluctuate or worsen over time, and full impairment. Consent capacity can be affected by a wide range of disorders and conditions such as dementia, stroke, intoxication, serious mental illness, and delirium. For example, certain medications for pain could impact consent capacity where complex decision-making is impaired, even though they can function independently. In certain cases, with diminished or partial capacity, the IRB may require use of an assent by the subject in addition to obtaining consent from the legally authorized representative or surrogate with use of IRB-approved method. The subject's level of capacity to provide consent helps dictate the level of involvement of the LAR or surrogate. If the subject is able to provide consent or assent based on their level of impairment and as approved by the IRB, the PI should be prepared to involve an LAR or surrogate initially or at later stages if consent capacity diminishes. When the subject's consent capacity is sufficiently impaired that the subject is unable to provide legally effective informed consent, the subject may not be enrolled unless the subject's LAR or surrogate consents on the subject's behalf. In emergency situations, where an LAR or surrogate is not available and the subject cannot provide consent, the PI may request expedited permission from the IRB to waive consent requirements. In other words, some emergency situations where the subject cannot provide consent, such as a stroke or car accident with head injury, there could be expedited permission to waive consent requirements. This is usually considered when planning the protocol, but some rare situations may exist where the potential benefit warrants such a waiver. If there is no appointed surrogate and there is IRB approval to utilize an LAR or surrogate, the research team must comply with state and local guidelines for obtaining and documenting consent. If you are unclear when a surrogate can be appointed or used, consult with the institution compliance and/or legal offices. Remember that informed consent is a process. This figure represents a brief overview of the informed consent process, including the introduction, explanation, comprehension, question and answer, and consent. When obtaining consent from a legally authorized representative or surrogate, these principles should still be followed. Each step is covered in detail in the Informed Consent Process and Documentation Procedure MG-O-004.05. All informed consent processes components that we will discuss assumes that you have a clear understanding of these steps. If you are unsure about any of these 5 elements, please take a moment to review the procedure before continuing. In addition to guidelines following the informed consent process outlined in Procedure MG-O-401, the following are some additional considerations when obtaining consent from a surrogate. If the person has formally designated someone as having medical decision-making authority on their behalf through a valid advance directive, the appointed surrogate has authority to consent the medical research on the person's behalf if the person is not about to consent for themselves. The surrogate should be consulted to make decisions on behalf of the subject and assure that any such decisions are in the subject's best interest throughout the duration of the subject's participation in the clinical research. The use of a legally authorized representative or surrogate for obtaining consent and, if assent is utilized, must be described in the documentation of the informed consent process and approved by the IRB of record. Consenting is an ongoing process. All applicable criteria that would trigger reconsenting a research subject in any way will apply to research subjects whose consent has been provided by a surrogate. A research subject who regains cognitive ability to consent must be consented using standard consenting procedures. For guidance on standard consenting procedures, please refer to Procedure MG-O-004.05.
When obtaining consent while using an LAR or surrogate, there are several documentation requirements. The LAR or surrogate will sign the informed consent form on the appropriate line modified to include a signature block for the LAR or surrogate. In some situations, there is a space on the informed consent form for an LAR or surrogate to sign, but there is no need for an LAR or surrogate for the patient. If the patient can provide consent on their own, but a caregiver is still required for the study team should note that there is no LAR and explain why the section does not apply in this case. Proper documentation in the informed consent process is vital to understanding how consent was obtained for every subject. A signed copy of the informed consent form must be provided to the LAR or surrogate. An original or certified copy of the entire signed informed consent form must be retained in the study records. The research staff performing the informed consent process must document that the process has occurred in the electronic health record or use a narrative consent note, which should be filed together with the consent form in the study binder. The information includes guidelines that follow MG-O-004.05. One major difference in the documentation of the informed consent process is the inclusion of details related to the use of the LAR or surrogate and assent when utilized. The same documentation information should be included in the informed consent process when obtaining consent from a surrogate, as listed in Procedure MG-O-004.01. The guideline titled MG-O-4GL1, Using MedConnect AutoText and PowerForms for Documentation, provides a template for documenting the informed consent process with use of an LAR or surrogate in the electronic health record. The same text can be used for a narrative note, which should be filed together with the consent form in the study binder. In summary, IRB and sponsor approval must be obtained before using an LAR or surrogate for consent. Refer to the IRB of record for policies on when surrogate consent is permitted. The level of capacity of the subject to provide consent dictates the level of involvement of the LAR or surrogate. Throughout this video, guidance on considerations of subject consent capacity was provided. Finally, additional consent signing and documentation requirements were discussed.
This concludes the overview of Procedure MG-O-4.05 on obtaining consent for research from a surrogate. If you would like more information on Joint GU-MHRI procedures, please visit the website shared on the screen or visit MedStar Starport. Take care.